Imagine it is 4:30 in the morning, still dark outside. A sheriff's sergeant is walking up your driveway while wearing night vision goggles. He walks past the gate, past your neighbor's homes, towards yours. Is it legal? Well, today we're going to talk about the Fourth Amendment, and specifically we're going to focus on curtilage, the area that intimately surrounds your home. And then we're also going to talk about the use of certain technology, namely night vision goggles. But before we go on, I want to thank you for watching me here on YouTube. If you're new to Lawstache channel, hit that subscribe button. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star rating. And finally, if you want to support this channel, consider going to shop.lawstache.com and check out some of the merch, including the Do Not Resist Person t-shirts. Thanks for watching.
Quick message from Lawstache. Are you charged with a crime? Or do you want to know your rights if stopped by police? Watch California attorney Anton Vieltsin discuss legal cases from the Supreme Court, Ninth Circuit, and California state courts on the Lawstache YouTube page. Anton has handled hundreds of federal and state criminal cases, has an in-depth knowledge of the law, and has the best mustache ever. Subscribe to the Lawstache YouTube page. That's Lawstache.
Today we're discussing People versus Lieng, a case from 2010, and it deals with curtilage and using night vision goggles. But first, let's talk about the facts. In 2008, Sheriff Sergeant Bruce Smith received a tip that there was a local marijuana grow from a property that was owned by two brothers, Richard and Tony Lieng. With that information in hand, the sergeant went to the property at 4:30 in the morning. It was still dark, and the sergeant was wearing night vision goggles. He walked up a driveway. The driveway was fenced in, however, the gate was open. And that driveway was also used by multiple properties, not just Lieng. So he walks up the driveway, goes up to a metal shed owned by Mr. Lieng and his brother. And he hears some fans going. He can also smell fresh marijuana. And because he's wearing night vision goggles, he can see a light coming from the crack underneath the door. He believes that the light is so intense that it must be coming from high intensity lamps often used to grow marijuana. With that information in hand, he puts it all together in an affidavit and submits it to a judge. He then gets a warrant to search the property. The officers, law enforcement, then execute that warrant, and they do in fact find a marijuana grow. The brothers are then charged with a number of drug-related offenses. But they make a number of arguments, and this is where we are, People versus Lieng. First, let's discuss the Fourth Amendment. The Fourth Amendment protects against unreasonable searches and seizures. And generally speaking, officers need to have a warrant before they conduct that search or seizure. Of course, here the officers eventually had a warrant to search the property. But that's not what we're discussing today. The brothers argue that the initial warrantless search, when the sergeant walked up the driveway, that was the Fourth Amendment violation. There was no warrant. He's using night vision goggles. He's going up the property, again, without a warrant. We know that the Fourth Amendment protects your home. Your home, in fact, is listed first in the Fourth Amendment and perhaps gets the most protection. But over the years, the Supreme Court has said that the area that intimately surrounds your home, called the curtilage, also gets the same protection. And anything beyond the curtilage is what's called open field. You do not get a Fourth Amendment protection in that area. The framework of curtilage has been given to us in the case United States versus Dunn from 1987. So let's go through the factors and determine whether this particular driveway was in fact curtilage and gets the Fourth Amendment protection, or if it's not curtilage and otherwise would be called an open field. The Supreme Court in United States versus Dunn in 1987 enumerated a 4-factor test in determining whether something is a curtilage or an open field. So first, we have to look at proximity. How close is the area to the house? Of course, again, this is just a factor. There's no right answer. The courts have to balance all these four factors and determine whether it leans one way or another. Over the years, courts have said that the area usually doesn't stretch more than 100 feet from the home itself. And here, the shed was about 150 feet away from the house. And so this factor leans towards the shed being in the open field versus curtilage. Factor number 2, enclosure. Is the area boxed in by a fence or a wall that signals that this is part of the house? Of course, here there was a gate, but it was open. And so it signals to general public that you can walk up to the house and, for example, knock or try to solicit if the gate is open. So again, this factor favors it being an open field. Factor number 3 is how you use the property, usage. Is the area being used for private, home life activities, or is it being shared? And here, this was a shared driveway used by at least 3 other properties. So it leans towards being an open field. And finally, factor number 4, the steps that the individual takes to shield it from the view. Here, the area, the driveway up to the fenced shed, that area was not being shielded from the general public. The gate was open, there was no trespassing signs. So to a general public, it would feel again that you could perhaps walk up the driveway, knock on the door, talk to the residents. And this area again is being used by 3 other homes. So all 4 factors, proximity, enclosure, usage, and the steps taken to shield the property, all 4 of the factors favor the prosecution. The court rules that this is an open field, not curtilage. And for that reason, that means the 4th Amendment does not protect Lieng. He does not get the 4th Amendment protection in the open field. So the officer could in fact walk up this driveway without a warrant because the 4th Amendment did not apply to the open field. The defense has a backup argument. They say that the use of the night vision goggles violated the 4th Amendment because it was used without a warrant. They rely on the famous Supreme Court case Kyllo versus United States. It is a case that I've discussed just last week, and it dealt with the use of thermal imaging device, which allowed law enforcement to literally look through the walls and determine that the inside of the house was warmer than any of the homes in the neighborhood. With that information, law enforcement believed that the house had a marijuana grow inside because the heat was being produced by the high intensity lamps that are often used in marijuana grow. With that information, law enforcement obtained a search warrant to enter the home. The case went all the way up to the Supreme Court, and the Supreme Court said that it is illegal under the 4th Amendment to use a thermal imaging device without a warrant on private property, on the home. So here, the defense is saying basically the same thing, that you should not be able to use night vision goggles on the property without a warrant. But in People versus Lieng, this case, the court says that there's a distinction. While the thermal imaging device is not used by the public, and it literally allowed law enforcement to look through the walls, something that they could not do with the naked eye. But here, they say night vision goggles only enhances your vision. And it is readily available to general public. You can buy night vision goggles at any sports good stores. So, for those reasons, they say Kyllo doesn't apply. Law enforcement can in fact use night vision goggles without a warrant. So, unfortunately, Mr. Lieng loses on both arguments. But why is this case important? Over the years, we've talked about curtilage many times. And if you go back through my channel, you'll see many examples of what worked and what didn't work in terms of protection under the Fourth Amendment. But this case reminds us that in order to invoke the Fourth Amendment, you have to fence in the property, make sure that individuals can't enter that area that intimately surrounds your home, have the gate locked, post clear no trespassing signs right on the fence, not buried somewhere down the property, right on the fence that you don't want people to walk in. Make sure you don't share the driveway or the property with other neighbors or other individuals. That means that perhaps putting your mailbox outside of that fence so not even a mailman can walk up to the property. Because if you're inviting general public to walk up to your front door, that means law enforcement can do the same thing without a warrant. I hope you enjoyed this video. I hope you learned something about curtilage and use of night vision goggles. If you're interested in a thermal imaging device use, look at the Kyllo case, which I posted about last week. Thanks for watching. If you're new to Lawstache channel, hit that subscribe button. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star rating. And finally, if you want to support this channel, consider going to shop.lawstache.com and check out some of the merch, including the Do Not Arrest This Person t-shirts. Thanks for watching, and I'll see you next Wednesday.